all right? So he told me that the last time I talked to him, all right? So all this interim about this TV card not working the way he wanted it to work, all right, could not work if it did not have the proper equipment to work with.
I got one question for you, Mr. Steininger. Why don't you just go to the store and buy a computer like most people do when they want one? Or go to Dell like you were talking about.
Because I wanted to run my old operating system, and he convinced me after 3 days that this would be a better way to go, it would be more reliable.
But you went to him first before he convinced you of anything, right?
I went to him to fix my old computer, which he was doing. While he was doing that, I was asking him questions about, you know, what kind of things might want to get on a new computer, that type of thing. And he was saying, well, geez, you know, I can do a better job, I can do this. And he convinced me that he could sell me a better computer than Dell could.
Well, I don't know. Evidently not.
Well, obviously not. The audio jacks still don't work. And
You know,
last time I was in there, I was told to live with it, with the problems that I'm having with the computer.
The defendant says he built a fine computer. It's just the plaintiff's bad decoder box. It's the old bad decoder box defense. Let's download the judge's decision and see what really happened here.
there are a couple of problems with this case. One is just the fact that it's dealing with computers, and I don't profess to understand computers very well. I have two of them at home, and they work. They do what they're supposed to do generally. They freeze up every once in a while, and I have to reboot them, and usually it works, and every once in a while there's spyware and crap like that gets on the hard drive, and I've got to clear all that stuff out, and I've learned after about 5 years how to do that. And so I can basically keep the computer running and doing what I want it to do, which isn't very many complicated things, you know. But still, I don't profess to understand these things. I will never understand them. You know, just something that's beyond me. And so when we're dealing with computer issues in a case like this, it's always a little bit hard for me because you're dealing with technical things that I just really don't understand too well. Maybe I understand a little bit, but not much. So when you're talking about going to him, to Mr. Evans, to have him build you a computer, I only very vaguely understand what that means. A little bit, then your defense is a defense that I don't completely understand either because you're dealing with issues, as I said, that are just beyond me. So it's always good if you ever have a case like this in the future to bring maybe an expert witness with you or somebody who can really talk to the judge in terms that a judge will understand when it comes to computers, and lots of times we just don't. But really, the bigger problem with the case is more of a legal problem. That's just kind of a personal problem that I have with it, and that is there's no real clear understanding between the two of you as to what was going to be done. This is a breach of contract case. From a legal standpoint, you're suing him because he breached the contract, the oral contract that you said he had with you, which was to build you this type of computer. And you're saying the computer doesn't work, and he, in effect, didn't build you the computer because it's not doing what you wanted to do, and you've given him an opportunity to fix it, and it's been over a year, well over a year, and he hasn't been able to do it, and so you're saying, breach of contract, I want my money back. But again, before you can have a breach of contract, there's got to be a contract between the two of you, something that is clearly understood, so I can determine whether or not there's a breach. Now, you don't have anything written in terms of the agreement, which is okay. You can have oral contracts, but still, the agreement has to be clearly understood, and it's really not here in this case. You know, you wanted him, Mr. Steininger, to build this computer for you by getting a bunch of parts and putting it all together. And I think Mr. Evans' idea of the contract was that he was going to get the parts that you wanted and simply put them together to do something, and that it should work. And if there are other problems with the computer that would not make it work, you were going to figure those things out, not Mr. Evans. And there's where the problem is. And now I've got to sort it all out. Because there's nothing written between the two of you, it's hard to sort it out. But what I'm going to find is that the agreement was for Mr. Evans to buy a bunch of parts, hardware, that are listed on this document here, or at least pretty closely listed. What?
There is a written part as far as warranty on the receipt, Your Honor.
Yeah, I don't care about the warranty, okay? Because where's the warranty? Where is it here?
It's on the second small receipt. It's a 1-year warranty.
second small receipt. Let's see what the warranty says. 1-year warranty on all parts. Okay, so, but we're not talking about parts here.
Parts don't work, Your Honor.
Well, we don't know if it's the parts that don't work or whether they were installed incorrectly or whether there's some bug with the parts that doesn't make them compatible with each other. That may be a problem here too. I don't know. That goes back to what I said earlier. So it's not a service warranty, it's a parts warranty. There's been no testimony that parts are defective. I mean, how would I know that? You know, the bottom line is the agreement seems to be that you paid Mr. Evans $1,145 to put this computer together. $1,070 of that was attributable to parts that work, as far as we know. At least there's no testimony that they don't work. If there's anything that doesn't work, it's Mr. Evans' inability to put it together properly. And that you only paid him $75 to do, according to this little piece of paper that you gave me. So I'll enter a judgment in your favor, Mr. Steininger, for $75. I'm going to add to that cost, consisting of a $45 filing fee and a $46 service fee. That's $166, I think, altogether. Yes. So that'll be the amount of your judgment, and the only thing I can tell you is next time, if you're going to have someone do something like this for you, get something in writing that specifies exactly what is going to be done and how much it's going to cost. So if there is a dispute, it's a little bit easier for a judge to figure it out, or go to Best Buy or Circuit City or any computer store and buy something new, and you probably won't have this problem.
Well, it's always good to know what you want. And in this case, the plaintiff wanted both parts and labor. But he could only prove that the labor was bad, not the parts. Unfortunately, he only got half of what he wanted. If you find that you are involved in a dispute that you can't resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Charlie Langton.